This is the first screenshot video for weeks 9 to 10, and it's to accompany the notes which I've placed on the screen for Chapter 6, and also a topic I'm carrying over or have carried over from Chapter 1, interpretation of contract language. So we've got three distinct categories of concepts to address in this chapter. The first one is Statute of Frauds, and the Statute of Frauds is a rule of contract law in most states, including New York. Much of it is migrated from the common law to legislation. But the Statute of Frauds requires that some contracts, to be enforceable, must be in a writing signed by the party against whom enforcement is sought. And since we never know who might need to later seek enforcement when we enter into a contract, if it's the type of contract covered by the Statute of Frauds, we're going to make certain, one, that it's in writing, and two, that it's signed by all of the parties to the agreement or to the contract. Why is there a Statute of Frauds? And there's different answers to that. And it seems to me that probably the best answer I could give you as this concept developed in the common law process and then later was legislated was that there was a concern that some contracts are so profound in terms of either changing the legal rights of or status of parties that we really want to make certain that there's almost a solemnity to entering into the contracts, which we accomplish by a signed writing. So let me just give you a thought here. If I want to sell my house and you want to buy it, it's not going to be a big deal for us to put our contract in writing and to sign the contract. But what I would be worried about is the owner of the house, or you would be worried about if you own a house, for someone claiming, well, we had an oral contract to sell without any evidence that such a contract was entered into. And that's a pretty big deal, obviously, selling one's house. Or how about another type of contract covered by the Statute of Frauds, a prenuptial agreement, an agreement that spouses enter into before marriage, which can profoundly affect their rights and obligations both during the course of the marriage and if the marriage comes to an end by way of divorce. And you can imagine if there's a divorce and if the parties could claim that there was verbal agreements that one of the spouses was waiving maintenance, or that one of the spouses had already opted out verbally to inherit property, etc., would be a total mess. So I think it's those types of contracts that really you're going to find in the Statute of Frauds. And the traditional categories of contracts, which are consistent with the New York Statute of Frauds, can be found on page 87, second column of the book in section 2 of chapter 6. So I'm asking you to please be able to identify these categories of contracts. And the two I already identified, transferring an interest in land or a prenuptial agreement, I identify in the notes and I referred to them. So that's our first category, a Statute of Frauds. Our second category that we're discussing is parole evidence. And parole evidence, or the parole evidence rule, is actually a rule of evidence, but it's traditionally addressed in contracts courses. And what we're looking at, if we're talking about parole evidence, we're looking at a written contract that's clearly the complete and final version of the contract between parties. It could have been a contract that the Statute of Frauds required had to be in writing, or it could have been a contract where the parties believed it was prudent to put it in writing, even if not required by the Statute of Frauds. And what the parole evidence rule stands for is this: if you and I enter into a complete written contract, we both should feel confident that neither one of us can claim later that there was a verbal, I'm going to call it side agreement. So the parole evidence rule would say that any evidence that tries to modify the terms of the written contract, if it's not consistent with the contract, is going to be not admissible because of the application of the parole evidence rule. Now, does that mean that parole evidence can never be used? And if we look at parole evidence as evidence just that falls outside the four corners of the written agreement, it can be used, but it can't be used to, as we've been saying, to modify the contract. It can be used in the case of unclear language parole evidence can be used in the case of unclear language to shed light on what the parties meant. I'm going to give you an example. One type of written agreement I deal with quite frequently in my law practice is a collective bargaining agreement, which is a written agreement between a labor union and an employer. And if you've ever seen a collective bargaining agreement, sometimes they're quite lengthy and they're quite detailed. They set forth, the terms and conditions of employment, benefits, promotions, how people are promoted, seniority rights, etc. And sometimes in those collective bargaining agreements, we run into unclear language, meaning the language is ambiguous. Recently, I had a situation where the language in the collective bargaining agreement stated that where there was a coaching vacancy in a high school and there was an applicant from within the teaching group in the high school and an outside applicant, the teaching applicant, or the applicant who was a teacher in the high school, was to receive, quote, first consideration, end of quote, for the position. And in context, the term, quote, first consideration, end of quote, is ambiguous. What does it mean? Does it mean that the teacher simply had to be interviewed first? Did it mean that his credentials or her credentials had to be considered first? Did it mean something deeper than that? For example, that there was a preference for the teacher over the outside applicant if the qualifications were generally equal, and we went on and on and on, believe me. But what would have been helpful, of course, there wasn't any parole evidence, but would have been helpful, and an example of parole evidence being used to not change a contract but give ambiguous language meaning would have been if there had been some notes about the negotiating history. In other words, what did the union and what did the school district say when this language was added to the contract? And that would have been very useful. In any event, there wasn't, and so we're waiting to see what the arbitrator is going to come up with in terms of the arbitrator's understanding of what first consideration means. Okay, and that sort of is a segue to our third and last category, which is interpretation of contract language. Now, the contract language could be verbal language, but probably in the real world where we run into interpretation is when it is written and, again, ambiguous. And so how does a court go about interpreting ambiguous contract language if that's an object of dispute in a lawsuit? And, for the lawyers and the paralegals helping them, once we know how the court's going to look at it, we can line up our efforts, we hope, at presenting evidence and our arguments that we hope are persuasive. And I have a case for you to read that I posted, and here it is, the Frigolament importing company case, and you can read it, but I just love this case. It begins, the issue is what is chicken? And you thought you knew what chicken meant. Well, in this case, the plaintiff who bought a bunch of chickens said that chicken means a young chicken suitable for broiling and frying. The defendant, however, said, no, chicken means any bird of that genus that meets the contract specifications on weight, including what it calls a stewing chicken. And as you work your way through the case, it's a big deal. This was chicken that was being, I think, exported to a European buyer, but the buyer thought that even the large chickens would be younger chickens that could be sold as with a retail understanding, or the buyer at the final link in the chain of purchase could broil and fry them. The defendant said, no, a chicken of that weight could be an old chicken. And, of course, if you know anything about chickens, an old chicken, they call it a stewing chicken because the only way you can make the meat edible of an old chicken is to stew it. If you do, by the way, you can come up with a pretty good chicken soup or a chicken fricassee, chicken and gravy. But what you're not going to do with an old chicken, because you know what happens with these old chickens, the meat gets tough and you can't broil it or fry it. So there was a lot of money on the table as the court addressed the question of what is chicken. Of course, the case has one of the greatest, to me, one of the greatest lines when he's referring to the testimony of one witness. And let me see if I can find it. Somebody goes, you're always all over the place. Well, I've got to find this testimony because it's worth it. It's defendant's witness Weiniger, and he operated a chicken viscerating plant, which would mean a plant where they cut up chicken. And he testified, chicken is everything except a goose, a duck, and a turkey. Everything is a chicken. But then you have to say, you have to specify which category you want or what you're talking about. So in any case, I have a brief description of the case in the notes and how the court went about looking at whether there was a contractual definition of chicken. There wasn't. The court analyzed the evidence, which I just quoted from part of it. Was there past trade usage, past practice between the parties, and then it's kind of interesting. There wasn't any trade usage, past practice, or contractual definition, and the court then ruled in favor of the seller, meaning the chicken seller who said an old chicken is fine, on the ground that the buyer didn't satisfy its burden of proof to establish the point that the chicken in the heavier pound categories was met to refer only to young chickens suitable for broiling and frying. But please read the case, and I think it would be a neat case to ask you a question or two about in our next little quiz. Okay, this will end this video.